Welcome to this Law of Self-Defense show for, what is today? June 21st, 2022. And this is a Law of Self-Defense Q&A show, question and answer show. So all of you can pose your self-defense law questions, ask the expert. That would be me, attorney Andrew Branca at Law of Self-Defense. Wow. What a greeting. Thank you so much. I can't tell you how much I appreciate it. And I will do my best to answer your self-defense law questions. Now, I do caution up front that what we do here is use of force law, meaning under what circumstances would it be appropriate or not to use various degrees of force in defense of yourself, defense of others, defense of property. We don't really do gun law here. Gun law is a completely different thing. Gun law addresses issues such as like who's allowed to possess firearms or other kinds of weapons, under what circumstances, what kind of licenses might be required, where can you carry or not carry, and so forth. We don't do gun law here. Frankly, gun law varies too much across the U.S., even within states, different counties, different boroughs, different cities within a state, that I think it's really impossible for anyone to claim on-demand expertise for the gun law of every jurisdiction of the United States. But self-defense law is ultimately pretty common across the 50 states. It's about 50% the same. In fact, it shares the same 5 elements across all 50 states, up to 5 elements. Many states don't require all 5 elements. Many states waive 1 or more elements under certain circumstances, but the most that's required is some combination of up to these 5 elements, which are innocence, imminence, proportionality, avoidance, and reasonableness. And you can get your own 5 elements of self-defense law cheat sheet at lawofselfdefense.com/elements. It's completely free, folks. Lawofselfdefense.com/elements. It's just a PDF download. But self-defense law is pretty much the same across the 50 states. It's about 20% different, mostly depending on whether or not there's a legal duty to retreat. But, and of course, there are other somewhat more modest variants. Of course, every state has its own statutes and case law, court decisions, and jury instructions, but the underlying principles are largely the same. And that's a reflection of how old self-defense law is. Our American self-defense law is derived from Old English common law before we became a country. And really, Western self-defense law dates all the way back to the ancient Greeks and Romans. So very, very well-established law. Hence the commonality across the 50 states. So come on in, everybody, make yourselves comfortable. That's always greatly appreciated. So here's how it's going to work. We're going to first address questions that were sent in by our Law of Self-Defense Platinum members. Platinum members, as part of their membership, get a exclusive question Q&A submission form on their membership dashboard where they can submit questions to me personally, directly. I receive all of those directly. And I answer those. And if they request that they be answered privately, I do that. Otherwise, we share the questions and answers publicly. But those are the only questions I guarantee to get an answer and a prioritized answer at that. So we'll cover a bunch of those Platinum member questions. By the way, folks, for those of you who wonder, the only people to whom we provide legal consult services in a self-defense case are our Platinum members. In the past, we would provide legal consult to anybody who could pay our retainer. Our retainer starts at $10,000 and goes up from there, typically a multiple of that amount, depending on the complexity of the case. But we don't accept non-member legal consults anymore. So we're not available at any price to do a legal consult on a use of force case unless the person requesting the consult is a Platinum member, and that Platinum member gets the consult for free as part of their Platinum membership. So if any of that's of interest, I've put in the, if you're watching this on YouTube at least, I've put in the description a link to learn more about our Platinum memberships. It's simply lawofselfdefense.com/platinum. In fact, I think I'll just add that to change my name here to that, lawofselfdefense.com. There we go. That's the URL you would use to learn more, and I explain the program in more detail. But one of the incidental benefits of being a platinum member is this platinum member exclusive Q&A submission form that they have access to. So we'll step through those questions first. Then I'll take questions that are submitted during this live show, but they must be in super chat form, and they must be a minimum of US $10. That's the way that works. There's no free questions submitted. Of course, you all get free answers. But if you'd like your question to be addressed during the show, it needs to be in super chat format. And the super chat needs to be a minimum of $10. Now, I'll address all of those that come in, but I will prioritize. In terms of the magnitude of the super chat amount. So the higher the amount, the higher the priority for getting the question answered, and the more detail I can invest in the answer to a particular question. Let me pull this up here, make sure I'm ready to take those super chat questions as they come in. Yes, so David writes, I could bump that up to $20. Well, it's only $10 because I need some filter mechanism. Otherwise, there are, unfortunately, people who will pepper 20, 30 questions into the chat. So to limit that, or at least make it a revenue center, we charge the nominal $10 amount. My billable rate's $1,000 an hour, folks. So $10 is a pretty good deal. All right, so if everyone's getting settled in, I don't think there's any super chats I need to address yet. Nope. All right, so let's go ahead and I'll start with my first question here, which is a pretty common one. So this is from Sarah. She doesn't indicate what state she's from, but it doesn't really matter. She writes or asks, if I'm involved in a self-defense incident and need to hire a lawyer to defend me, what questions should I ask a lawyer to help me determine that they have a good understanding of self-defense law, and would it be a good fit to defend me? It's a great question because unfortunately, most lawyers don't really know self-defense law. We're not taught this stuff in law school. Most criminal defense lawyers, which is what you'd be talking to in this situation, may have a lot of experience arguing bad guy cases of self-defense, but generally not a lot of experience arguing good guy cases of self-defense. Most of the older criminal defense attorneys I know, meaning in my age range, will tell me routinely that in a 3-decade career, they'll have maybe a handful, 5 good guy cases of self-defense. So once every 6 years, once every 10 years. And as you imagine, it's pretty hard to get really good at something if you only do it every half decade or every decade. Now, again, they have a lot of experience doing bad guy cases of self-defense. Those come up all the time. It's a routine legal defense you'd raise for any client who's charged with the use of force event. But most of those bad guy cases of self-defense are pretty easy to defeat. They tend to be inherently defective. They're crushed pretty efficiently by the prosecution early on. And you end up with defense attorneys who are a lot like a football team that has a great deal of experience getting to the 50-yard line, but never actually scoring a touchdown. That's just, and it's not because they're bad attorneys. It's because they're stuck with the facts their bad guy clients give them, and bad guy claims of self-defense tend not to have great facts. So it's good to be prepared to be able to vet to some degree your prospective criminal defense attorney. So how do you go about doing that without going to law school yourself, which frankly probably wouldn't be that helpful, because again, in my 3 years of law school, we spent maybe 5 minutes on self-defense law. Again, we're not really taught this stuff in law school. So even that probably wouldn't be all that helpful. Frankly, the best advice I can give you is to be an informed consumer. Now, there aren't individual specific questions I could give you to ask, because the questions you would want to ask would be very specific to the facts of your particular case, and the facts come in infinite variety. But generally speaking, one of the best ways to be an informed consumer on self-defense law services, legal services, is to get a copy of our book, The Law of Self-Defense, which we make available for free. Let's see if I still have that here. Well, it looks like I don't have that little image anymore, but you can see the URL right below my face here. At least, yeah, should be able to see it. lawofselfdefense.com slash free book. You can also get the book on Amazon if you want. They'll charge you for the book and shipping and handling. We only ask that you cover the cost of getting the book to you, the shipping and handling part. We give you the book for free. If you want to check out the reviews on Amazon, there's over 1,000 of them. It's solid 5-star rating. But I would encourage you, no sense paying for the book if you can get it for free. Get it at lawofselfdefense.com slash free book. Very easy to read. The biggest compliment we get on the book is that it's readily accessible to lay people. And most people tell me they get through the entire 200-page book in 3 or 4 hours. So it's one afternoon of reading. And what that does provide you is a robust, principled, legal principled understanding of self-defense law. And it puts you in a position so whatever the facts of your particular use of force event may be, at least you're well positioned to know what kinds of questions to ask a criminal defense lawyer and have a sense for what kind of answers you should get back. If you can't even do that, then any criminal defense attorney is going to sound like a genius because they know something and you know nothing. And that's not a good place to be, folks, because lawyers, like any other profession, are on a bell curve, right? Most of them are somewhere within the middle range, somewhere within a standard deviation or so. Some of them are outstanding on the far right of the bell curve. And unfortunately, some of them are on the far left of the bell curve. And you don't want that legal representation. So I would urge you to be an informed consumer. The best way to do that is to invest 3 or 4 hours into our free book, the lawofselfdefense.com slash free book. Simple enough. If you are a Law of Self-Defense Platinum member, part of your Platinum membership benefits is I will be happy to vet any criminal defense attorney you're considering. As a Platinum member, of course, I don't represent you as your lead counsel in the case. You would have local lead counsel. I'm consulting to that attorney on your case, but I'm happy to talk to your lead counsel. And if they seem like they're a particularly bad choice to me, I would certainly let you know that. But if you're not going to be a Platinum member, the best alternative approach would be to at least invest a little bit of time or get the audiobook version of the Law of Self-Defense and become sufficiently informed that you can be a prudent consumer of legal services. By the way, keep in mind, you can talk to as many prospective attorneys as you want. You're not stuck with any particular one. You can interview a whole bunch of them. You're not stuck with the attorney who did your arraignment, who arranged for your bail. You're not stuck with the first attorney you pick or the second or the third or the fourth. And you need to be extremely confident in your defense attorney because they have your entire life in their hands. You need to be confident that they are fully committed to your defense and know what they're doing. Otherwise, I mean, it's stressful enough even when you have that on your side and you are confident in the abilities and willingness to fight of your lead counsel. If you don't have that on your side, that would be a terrible position to be in. Okay, so hopefully that answered Sarah's question. Next, we have a more complex question that will end up being pretty much an in-depth primer on defense of dwelling law, which is, of course, one facet of defense of property. Let me refresh this. Here we go. Okay, so let me get to, this is from Frank in California. Frank writes, I know California has a castle doctrine. If you would please discuss the difference between these two scenarios. And then he sets out two scenarios, and I'll come back to those in just a moment. But it's important to understand what castle doctrine actually means. So yes, California has a castle doctrine. Every state has a castle doctrine, every single one. There's no exception if you have a proper understanding of castle doctrine. So all castle doctrine does is say, if you would have had a legal duty to retreat before you could use deadly force in self-defense, you are relieved of that legal duty to retreat if you are in your castle. Every state has some flavor of castle doctrine. Now, castle doctrine does come in different flavors. So one of the variations is what qualifies as a castle. So your dwelling always qualifies as a castle for castle doctrine purposes, and that includes temporary dwellings. So, of course, when you're home, but also if you're traveling and staying in a hotel, for example, while you're staying at the hotel, your room is your castle. Now, not the common areas of the hotel. The hallway outside your room is not part of your temporary castle, but your room is. If you own an RV, normally a motor vehicle is not a castle if it's unoccupied. But if you're, and especially if it's something you wouldn't live in, but if you're using your RV on vacation so that you're living in it during that vacation, that becomes your castle while you're living in it. If you're camping in a tent in the woods, your tent becomes your castle for castle doctrine purposes during the period you're living in the tent. So that's one facet of what qualifies as a castle. It's always some form of dwelling, a shelter for people, and it can be a temporary dwelling. Then some states expand castle beyond that to include things like a place of business. Sometimes it can be anybody's place of business. You could be a customer in a store. Other times it has to be your business. Your business becomes your castle. And then many states include motor vehicles if they're occupied. So you're in the motor vehicle, or I guess theoretically you're defending someone else who's in the motor vehicle. That becomes more, there's some subtleties there. But if you're in your own motor vehicle, many states will treat that occupied motor vehicle as a castle for castle doctrine purposes. Again, the limited meaning of which is if you would otherwise have had a legal duty to retreat, you are relieved of that legal duty to retreat while you're in your castle. Another variation in the flavor of castle doctrine is who can claim castle doctrine privileges. So when you're in your home, you can claim castle doctrine privileges, certainly against a genuine intruder. But what if you're a guest in someone else's home? So it's still a castle, but it's not your castle. It's the homeowner's castle. So they would have castle doctrine privileges there. Whether you would or not is one of the various flavors of castle doctrine. Some states say you have castle doctrine privileges too, as long as you have license to be there. You're an invited guest. Others say that the castle doctrine is limited to the actual dweller, not guests. Another variation is who you can claim castle doctrine privileges against. You can always claim castle doctrine privileges against a genuine intruder, someone unlawfully, forcibly entering your home, for example. But what about against someone who also lives there? It's their castle too. It's a spouse or a co-dweller. Some states say, hey, you get castle doctrine privileges against an intruder, but if it's someone who's also their castle, no castle doctrine privilege for you. You regain that otherwise existing legal duty to retreat. And that can apply also to invited guests. So if you invite a guest in, or you invite a repairman in, while they are present by license, you don't have castle doctrine privileges against them in some states. Some states don't care about that, but some states do. Now, the good thing about the guest scenario or the repairman scenario is that it's easy to turn them from someone who's there by license to someone who's a trespasser. Just tell them to get out. And if after given a reasonable opportunity to obey that instruction, they don't get out, now they're not lawfully present anymore. Now they're a simple trespasser, an intruder, and would fall under the castle doctrine umbrella. So those are most of the various flavors of castle doctrine. But the important thing is that's all that castle doctrine means. If you would otherwise have had a legal duty to retreat, you are relieved of that legal duty if you are in your castle defending yourself and you fall within the particular scope or flavor of the castle doctrine in your jurisdiction. Folks, if you're going to submit a question for me to answer as a super chat, it needs to be $10. Otherwise, I'm not going to be able to get to it. So, as I said at the start, but I'll repeat from time to time for people who come into the live show as it's proceeding. All right, so that's what castle doctrine means, properly understood. And in that proper understanding, every state, all 50 of them, has some flavor of that castle doctrine that relieves you of an otherwise existing duty to retreat. So Frank here from California goes on. Here are his two scenarios. One, someone is kicking in the front door to unlawfully enter my home. When the door breaks open, I shoot and kill the intruder. So what we have here in this scenario is someone who's not merely unlawfully entering, they're unlawfully and forcibly entering. And that's an important distinction. Many states have a special provision that of law that creates a legal presumption that someone who's forcibly and unlawfully entering your home is legally presumed to be reasonably perceived as an imminent deadly force threat against the defender. And folks, that effectively, I mentioned earlier, the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. This legal presumption, when you're facing a unlawful and forcible intruder into your home, it's presuming imminence, it's presuming proportionality, that it's a deadly force threat, and it's presuming that your perception is reasonable. That's 3 of the 5 elements of self-defense. You're in your castle facing an intruder, so castle doctrine presumes that you have no legal duty to retreat, or relieves you of that legal duty to retreat. That's 4 of the 5 elements of self-defense that are given to you by this legal presumption of reasonableness when you're facing someone who's unlawfully and forcibly entering your home. In most states that have this special legal provision, it does have to be both characteristics. Unlawful alone is not enough. Unlawful and forcible. And that's covered here in Frank's scenario. Someone is kicking in the front door to unlawfully enter my home. So they're entering unlawfully and they're doing it forcibly. Now, why do we have this dual requirement, unlawful and forcible? It's because the law is concerned about what we might call the innocent intruder. So someone who's present unlawfully, but without malice. The law doesn't want to presume that you have the privilege to legally kill that person, the innocent intruder. Now you might be thinking, what the hell is an innocent intruder? Well, it could be a repairman sent to the wrong address. It could be a repairman who's told, listen, go to this address. The people can't be home, but their dishwasher needs to be fixed. They're going to leave the back door unlocked so you can get in and fix it while they're at work. And then they give the repairman the wrong address. So he goes to the wrong home. And sure enough, the back door is unlocked and he walks in. Now, he's present unlawfully. He doesn't have license by the actual homeowners to be there. He's trespassing. But he's not there to act with malice against someone. He's not there to hurt anybody. It's an innocent mistake. This can also not uncommonly happen for folks who may live in a place where a lot of the housing is identical. If you've been in certain apartment buildings or condo complexes, to a stranger, they all look the same. And sometimes people have out-of-town guests who go out for the night and have a few drinks, maybe a few drinks too many, and come back in a enjoyed state and mistake an apartment for the one they're supposed to go into, and they walk in to the wrong apartment. Again, they're there unlawfully. They don't have license to be in the wrong apartment, but they're not there with malice. They're an innocent intruder. So the law says, hey, if there's a possibility it's an innocent intruder, we don't just want you to give you license to shoot that person in the face the moment you come across them. We're not going to legally presume that they are in imminent threat of deadly force harm to you, unless it was both unlawful and forcible. They broke something to get in. Because there may be an innocent explanation for why someone's present unlawfully. There's no innocent explanation for why they're present unlawfully and broke something to get in. If they broke something to get in, that's a forcible entry. That absolutely distinguishes between the innocent intruder and an unlawful and malicious intruder. Which, by the way, folks, is a pretty good reason to keep your doors locked, even when you're home. And by locked, I mean, even if it's just a screen door with a little latch hook, compel that criminal intruder to break something in order to get in so that you qualify for that legal presumption of a reasonable fear of imminent deadly force harm, that you qualify for that presumption. 4 of the 5 elements are given to you. And really, folks, for all practical purposes, it's all 5 elements. So you get imminence, proportionality, and reasonableness from the legal presumption I talked about. You get avoidance from counsel doctrine. And the last element is innocence. And innocence is pretty much baked into the cake if you're defending against an intruder into your home. So it becomes an almost impossible self-defense case for a prosecution to overcome. Now, unfortunately, while it's really hard for a defender to screw up that scenario, sometimes people do. So sometimes they'll scare the intruder away and chase him down the street and shoot him in the back as he's running away. That would no longer fall under that legal presumption. So you don't want to do that. So that's the first scenario. Someone's kicking in the front door to unlawfully enter my home, and the door breaks open. I shoot and kill the intruder. Almost impossible to screw up that particular defensive use scenario. The second scenario, I wake up in the middle of the night and hear noises in the living room. I go to investigate and find an intruder has broken in and is holding my TV in his hands. In that scenario, the intruder is already in the house. I would hold my firearm on them, but I would recognize that their intent is to steal the TV, so I would not fire unless they made a threatening move towards me. Well, the law would require, so you need to be facing an imminent deadly force threat before you're privileged to use deadly defensive force against someone. Now, as I just said, in the context of a forcible, unlawful intruder into your home, you may get a legal presumption that there's an imminent deadly force threat. But the law is still requiring it. Even then, they're just presuming that the requirement has been met, if that makes sense. It's not waiving the requirement. And also, folks, really, do you want to be shooting someone who is not presenting any kind of threat? I mean, you're incurring a lot of risk. Keep in mind, there's no magic spell that keeps a prosecutor from dragging you into a murder trial. If they want to bring you to a murder trial, they will. And they will compel you to argue to the jury that your shooting of that other human being dead was legally justified. And maybe all the facts going into the trial are overwhelmingly in your favor. And the prospects of getting convicted are really low. But they're never zero, folks. There's always at least a 10% chance if we put you in front of a jury that you're going to get convicted, no matter how innocent you are, no matter how justified your use of force was. That's just the noise in the system. So if you do get convicted and it's a killing charge and you're looking at 20, 30, maybe years in prison, maybe life in prison, was it worth it over somebody who was not actually presenting you with any threat? Because that's what we're presuming here. We're presuming that it's apparent that they're not presenting a deadly force threat. Now, if it's more ambiguous than that, or if there's a reasonable perception of a deadly force threat, well, that answers the question, right? You have to act consistent with your own safety and the safety you have others to protect. But if you really believe they're only there to try to walk out with your property, first of all, you can't kill in defense of property. And second of all, would you want to? Would you, and put aside moral and ethical reasons, of course, there's arguments there as well. But in terms of pure self-interest, do you want to subject yourself to a trial in which no matter how innocent you are, there's a 10% chance you get convicted and go to prison for the rest of your life? And even if you're acquitted, expect to spend perhaps hundreds of thousands of dollars in your legal defense. Is that worth it over TV where there's no reasonably perceived threat of harm from that intruder? I mean, I don't tell people what to do in self-defense. I'm not telling anyone what to do in this scenario. I just try to put people in a position where they can make an informed decision. And I do urge you to think about it before you find yourself in the moment. Because in the moment under stress, it's impossible to, we don't tend to make better decisions under stress, right? We tend to make worse decisions under stress. All right, so let's see. He's just holding the TV. And here Frank is saying he wouldn't shoot unless they made a threatening move towards me. I think that's a reasonable position to take. He asks, would self-defense apply in the second scenario if I shot the intruder holding the TV? Well, are they presenting an imminent threat of deadly force harm? If you have that reasonable perception, then the use of deadly defensive force would be justified. If they're not, If it's a big, heavy TV and both their hands are on the TV and you can see they're not reaching for a weapon, they're not sufficiently proximate to, say, strike you with the TV, what would be the rationale, the legal justification? And by the way, even the states that have this legal presumption that with a forcible unlawful intruder, first of all, were they forcible? Or did you leave your patio door unlocked and they just slid open the door and walked in? That's not a forcible entry for these purposes. So many times these legal presumption statutes require not only that they forcibly entered, but that you had reason to believe there was a forcible entry. You heard glass break, you heard a door frame shatter, for example. You're not allowed to just speculate that they entered forcibly. So did they enter forcibly when they came in to steal your TV? But in any case, again, if they are not apparently presenting a deadly force threat, do you want to shoot them even if the law would allow? And of course, it becomes a lot more sketchy. And by the way, these legal presumption statutes, they are rebuttable presumptions, meaning they can be overcome by the prosecution. So say, for example, there is a forcible, unlawful intruder in your home. You encounter him in your living room. And the minute you encounter him, you point your gun at him and he throws himself on the ground and says, "I give up." And his hands are splayed out. And you shoot him in the back of the head. Now, the statute provided you with a legal presumption that you were facing an imminent deadly force threat, but that presumption can be rebutted, can be overcome by the prosecution if there is evidence that, in fact, those elements, the imminence, the deadly force threat, the reasonableness of your perception were not present. The prosecution is free to try to overcome that legal presumption. So the evidence better be consistent, at least not inconsistent, with those elements that are presumed, but not absolutely locked in when you're dealing with a forcible and unlawful intruder. And at another level of explanation here, when Frank asks, will self-defense apply in the second scenario if I shoot the intruder holding the TV? When we say, will self-defense apply, we need to understand what we're really saying there. Can you raise the legal defense of self-defense? Yes. Will it work? That's a entirely different question. So does it apply in the sense that your lawyer will likely be free to raise the legal defense of self-defense? By the way, your lawyer is not always free. You don't have some absolute right to raise the legal defense of self-defense. The judge has to approve. You have to qualify. You have to meet what's called your burden of production, producing some minimal amount of evidence in support of self-defense before the judge will allow your lawyer to even mention self-defense to the jury. But that's the question. Will it apply? Generally, for good guy cases of self-defense, you can almost always get the self-defense instruction, get permission from the court to argue self-defense. That doesn't mean it's going to work. That's a completely different question. Okay, so let's see. Joseph sent a video. I did not notice this was a video until just now. Let me see if I can take a quick look at it. Let's see. I'll see if we have any actual interesting. It looks like it's just on the scene footage after the fact. So the video is not interesting, but the fact pattern is. So I'll read you the headline of this news article, and it reads, shooting at Phoenix gas station, man pulls out replica gun, killed by another man with a real gun. If this sounds insane, folks, this happens with some frequency. Often there are people who are pulling out fake guns on police officers. And of course, the police officer shoots back with a real gun. And as you might imagine, the outcome is typically not good for the person with the fake gun. But how does the law treat this? Well, what the law requires before you can use deadly force in self-defense is that you have a reasonable perception of an imminent deadly force threat. Your perception does not have to be correct. Self-defense as a legal defense does not require perfection. It requires reasonableness. So if someone threatens you with what appears to be a real gun, it doesn't matter if it later turns out to be a toy. If a reasonable person would have perceived it as a real imminent deadly force threat, you're allowed to defend against it as if it were a real imminent deadly force threat. And if it later turns out to have been a toy gun that couldn't actually cause death or serious bodily injury, that does nothing to diminish your legal defense of self-defense, so long as your perception of it as a deadly weapon was a reasonable perception. By the way, this is true even if you don't actually see a weapon. If someone approaches you wearing a hoodie and they have their hand in the hoodie jacket and they use their finger to replicate what the barrel of a gun would look like, as if they had a gun inside the pocket of their hoodie, and they say, give me all your money or I'll shoot you, you could well have a reasonable perception that they really have a gun and respond accordingly, use deadly defensive force, because they created that reasonable perception of an imminent deadly force threat in your mind. But whether or not the threat is genuine, is true, is real, is largely irrelevant to the legal analysis. What the legal analysis requires is that your perception of the threat as an imminent deadly force threat was a reasonable perception, which does mean, by the way, that it can't be merely speculative or imaginative. So saying, well, for all I know, that guy could have had a gun or he could have had a knife, absent evidence from which a reasonable person could infer a gun or a knife, that's not going to work, folks. Everything you do in self-defense, one of the 5 elements of self-defense is reasonableness. Reasonableness is the application of your powers of reason to facts, to evidence, to observations. You need to see something from which you could reasonably infer a weapon. There doesn't have to be a weapon, but your inference of a weapon has to be based on something concrete, something that you can articulate to others. I mean, you may have heard self-defense experts, or maybe the guy who taught your concealed carry course, tell you that, when you act in self-defense, you better be able to articulate your rationale for having done that. And that's true. You do need to be able to articulate the facts that would support self-defense, but that articulation does have to be supported by facts. It can't be supported by merely speculation or imagination. The guy with his hand in the hoodie doesn't actually have a gun, but he's pointing his finger in the pocket saying, give me your money or I'll shoot you. I would argue you can make a reasonable inference that he has a gun there, and that's all that's required. Someone whose hands are in plain sight and they're not verbalizing that they have a gun and they're not making any motions, no physical conduct consistent with accessing a firearm, then you're just speculating or imagining that they could have a gun, and you can't kill someone based on that. All right. Next, we have Brian P. Oh my gosh, it's another video. Let me see if I can tell what's going on here. This would make an interesting lawful use of deadly force in defense of others analysis. I'm thinking the only person privileged to shoot when they all did was a police officer. The immediate threat appeared to end when the suspect turned to flee. Let me take a quick look at this video. I think I already know the one he's talking about. Yeah. Okay. This is the story that came out earlier this year about the man who came into a concealed carry course, sat down like a student, and then tried to rob the people in the class. My recollection is he had a knife. That's my recollection. There's no text here. But anyway, unfortunately, it's kind of foolish to bring a knife to a gunfight in a concealed carry course where plenty of those people are likely to be armed. Certainly the instructor is likely to be armed. And it did not work out well for the intended robber. He fled the classroom. He fled out into the parking lot and was followed by several students from the class who were presenting guns at him. And a police officer also responded, and he was shot and killed. And I believe not only the police officer fired shots, but I believe some of the students from the class also fired shots. Now, this is much more sketchy than it would appear, because certainly in the classroom, when he's threatening people with a knife, he's presenting as an imminent threat of deadly force harm. Had they shot him in the classroom, it would be hard to see how that wouldn't be lawful self-defense. But once he flees and they're pursuing him out in the parking lot, is he still presenting as an imminent deadly force threat to anybody at that point? And I would be very careful about going down the citizen's arrest line, because in many states, citizen's arrest is a lot more complicated than you might think. In Georgia, where the Ahmaud Arbery case happened, where the defendants in that case sought to raise citizen's arrest as a legal defense to their threat and use of force against Ahmaud Arbery, that citizen's arrest statute was so old, and so I believe it dated back to 1865, was so ambiguously worded, using legal terms of art, the definition of which had changed substantially in the mid 1900s from what those words might have meant when the law was created in 1865, that no one really knew how to apply it. Certainly the trial court didn't know how to apply it. The judge read the jury the citizen's arrest statute and left it completely ambiguous, which frankly, in my opinion, is a reason to reverse the convictions in state court of those men all by itself. But in any case, the state of Georgia decided to repeal that citizen's arrest statute. And now effectively in Georgia, there is no privilege of citizen's arrest at all to hold anyone at gunpoint for any reason, even if they are an intruder in your home. So there is a narrow carve out for merchants who come across a shoplifter. But in terms of a general privilege of citizen's arrest, Georgia has none right now, which means if you're chasing someone with a gun, what's your justification for doing that? Because it can't be citizen's arrest, which doesn't exist under Georgia law. If you were doing that in Georgia, for example. But in any case, you always run the risk that when you go to the fight rather than the fight coming to you, it doesn't really look like self-defense to anybody. Now, of course, police are in a different situation. Use of force law for police is really the same as for civilians in most senses, but the flavor of it changes a little bit. So, for example, you and I, who are not law enforcement officers, those of us who are not law enforcement officers, we're never permitted to be the initial physical aggressor in a confrontation. That would lose us the element of innocence, lose us self-defense. Innocence is always a required element of self-defense. It's never waived under any circumstances. But police officers are licensed by the state to be the initial aggressors in conflict. And it happens all the time, right? The people who first threaten or use physical force, it's part of their job in making an arrest, for example. So the police, of course, are allowed to go to the fight. Uvalde, Texas, beside the point. And so they don't run the risk of losing their privilege to use deadly defensive force simply because they pursued someone, ran someone down in a parking lot. But civilians might be running that risk. And again, you're going to the fight, and why? Because you're mad? Because the person, if they're fleeing, even if they have a knife, they're not threatening you anymore. And that's kind of the goal, right? Is to survive the fight, not to play a junior police officer. So I don't know what happened. I don't remember hearing that any of those civilians were charged with anything. But that would be a largely discretionary decision by the prosecutor. I forget where this happened, but I believe it was in a gun-friendly state. If this kind of thing had happened in a state like Massachusetts or Maryland or New York, it could have been quite different legal outcome. Remember, whether or not a prosecutor ultimately charges you is almost entirely up to their discretion. There's supposed to be effective legal hurdles they have to overcome before they can drag you into court. In my opinion, there are no effective legal hurdles to the prosecution's discretion. We don't have proper probable cause hearings in this country. If the prosecutor tells a story of guilt to the judge pre-trial, the judge is going to allow you to be dragged into trial. I think it's terrible. I think it's a denial of fundamental due process of law. I would love it if the Supreme Court did something about that, but so far, that's the state we're living in. If the prosecutor wants to drag you into trial and there's even the faintest whiff of evidence, nothing close to probable cause, just a mere whiff of evidence to support the prosecution's argument for concealed carry, for dragging you in the court, off to court you go. All right, let's see. The next platinum question is from Warren out of South Carolina. Warren asks, my question concerns pepper spray guns that shoot pellets like a paintball and tasers. Yes, I did a blog post on one of these makes of guns. What the heck was it called? If anybody remembers, there's a brand of pepper spray gun that fires a pepper spray pellet of some kind. I'm blanking on the name of the company. I did a blog post on them, an unfavorable blog post on them for reasons I'll explain in a minute. And I got a rather heated response back from the company CEO. Didn't change my legal opinion, however. But these pepper spray pellets release pepper spray on impact when they're fired from this quote unquote gun. Do you recommend these as a non-lethal way of self-defense? The guns do come in a variety of colors. Byrna, that's it. Byrna, that's the company. Byrna was the one I wrote about. There may be other companies too. I don't know. But Byrna was the one I had written about. The guns come in a variety of colors. Some of them are orange. Some of them are just black. So they look exactly like an actual firearm. If I revealed the black gun, could I be charged with brandishing? If I have the orange gun, could I be charged with brandishing? I have the same questions regarding the taser gun. Although I have not purchased the gun, I think it's black with an orange tip. Well, tasers also come in a variety of colors. Black with large areas of yellow is the most common, but there are all black tasers too, which could easily be mistaken for a real gun. Maybe not to a real gun person. Even then, however. So here's the risk. And here's why I don't like these things. It's because they especially in the all black version, they so closely resemble an actual firearm. Now, they're not an actual firearm. They are what would be classified for defensive use purposes as a less than lethal weapon. So not likely to cause death or serious bodily injury. And presumably you would have it to use in that context where you're facing a non-deadly force threat, because you can't go to a real gun until you're facing a deadly force threat. So for purposes, I mean, I've said this 1,000 times, but I carry a gun every day for personal protection, have my entire adult life. And every day I carry a gun, I'm also carrying pepper spray because I know based on Department of Justice, FBI statistics, that I'm 5 times more likely to be faced with a non-deadly force threat than with a deadly force threat. And going to the gun against the more common non-deadly force threat is typically not a lawful use of a firearm. In which case you could be looking not just at a brandishing charge, but an aggravated assault with a firearm charge. Now, brandishing typically is just a misdemeanor. I mean, that's bad enough for a normal law-abiding citizen. But aggravated assault with a firearm is good for 10 to 20 years in prison. It's a very serious felony. And what's required? What are the elements that a prosecutor has to prove for a criminal charge of aggravated assault with a firearm? Well, fundamentally, the elements are that you put someone else in imminent fear of death or serious bodily injury. Can that happen if you point what appears to be a gun at someone? Yes. You are apparently threatening them with deadly force harm. Now, just as if you were holding a real-looking toy gun, you're not actually threatening them with deadly force harm, but that's not what matters for an aggravated assault charge. What matters is that other person's, the victim's, reasonable perception. Did you create in their mind a reasonable perception of an imminent threat of deadly force harm with a firearm, which would be an aggravating factor? And if you have one of these Byrna pistols in all black, it looks exactly like a regular handgun, like a Glock, for example, or something similar. You point it at someone, it's highly likely they're going to perceive that not as a pepper spray gun. Hardly anybody knows what a Byrna is. They're very likely to perceive it as a real gun being pointed at them. And now you've arguably committed the crime of aggravated assault with a weapon, with a firearm, good for 10 to 20 years in prison, that you now have to justify as self-defense. But were you justified in creating a reasonable fear of imminent death in their minds if they were only presenting as a non-deadly force threat against which pepper spray would normally be appropriate? No. So now you have a serious problem because you've checked off the elements for aggravated assault with a weapon and you don't have a deadly force self-defense justification for having done that. Presuming, of course, that they were not actually presenting as a deadly force threat. Presumably, if they were presenting as a deadly force threat, you would have gone to a real gun, not this fake pepper spray type of gun. I prefer my pepper spray. Now, listen, I'm an advocate, again, for having a non-deadly means of self-defense on your person, but I prefer my pepper spray to be in a container that cannot be readily confused with a real firearm for that reason. By the way, anytime you present a gun, you're running a risk that some other law-abiding citizen who has their own gun, or a passing police officer who, of course, will have their own gun, might perceive you as someone who's wielding that gun unlawfully, as being a criminal aggressor, and shoot you. Now, they're unlikely to do that if you're holding up a traditional pepper spray canister, because you're not presenting as a deadly force threat to anybody if you're doing that. But if you're waving what appears to be a gun around, might some other law-abiding person who turns the corner or walks through the door into the convenience store think you're the guy committing the armed robbery because you're all they see, and shoot you? Yeah, listen, people shoot other people mistakenly but lawfully, awful but lawful, cases of deadly use of force all the time. So it's not a risk I would want to run. If I'm going to run the risk of being shot because I appear to have a gun in my hand, it's going to be because the circumstances required me to have an actual gun in my hand. Okay, so I'm not a fan of these burner guns. I have a very traditional pepper spray canister I carry. It happens to be a Saber product. I'm a fan of the Saber products. POM, P-O-M, pepper spray products are also quite good. I don't claim expertise on pepper spray. I'm passing along the advice I received from Chuck Haggard, a self-defense trainer of considerable repute and capability and knowledge, expertise, who does a lot of pepper spray training and is qualified to give that opinion. So I'm simply passing on his opinion. Saber products, POM products are very good. There may be other good products too, but there's also a lot of bad ones. So those are the only ones I suggest people take a look at, unless they have good reason to believe otherwise. I believe it was Kimber used to have a rather oddly shaped pepper spray device where you could, it was almost like a small brass knuckles kind of configuration. It didn't look like a gun. That would be fine too, but I don't believe they manufacture it anymore. Okay, he says, I have the same question regarding a taser gun. Same issues with a taser. If it could be mistaken for a real gun, you run into all the same problems. I would also caution that I'm not a fan of tasers for civilian self-defense. Tasers have an unbelievable failure rate. And the failure rate can approach close to 100% if the person you're threatening with the taser knows how to defend against the taser. It's not that hard. And most bad guys will know how to defend against a taser. I don't want to go into that in detail because I don't want to be a trainer of how to defeat a taser. But even when they don't know how to defend, the tasers often don't work. When they work like they're supposed to, they're amazing. They completely neutralize the threat, at least while the juice is running. But very, very often they don't work. And the ideal use of a taser by police usually involves a scenario where you have one cop who's armed with a taser. They're trying to use less than lethal force to neutralize a threat, and another cop right behind the first cop who's armed with a firearm. So if the taser fails and suddenly they have to deal with a deadly force threat coming at them, there's a gun out already. Most civilians are not going to have a second person with a gun backing them up while they're using their taser. So I don't think it's a great fit for civilians. I think, frankly, they don't work all that great in the hands of cops, but at least with cops, they might find themselves in a situation where they would have a gun as a backup, a gun in someone else's hands as a backup to the taser should it fail, as it often does. And of course, it's not a bad thing for, just like I recommend for civilians, if you carry a gun, carry a non-deadly means of self-defense. It's good for the cops to have the same option. And when they do work, the tasers, they are awesome. It's just that they often don't work. Let's see. D asks, came across an article from Caliber Press providing some additional information to questions about a taser as a deadly force weapon and an officer's reaction to a grab attempt. Is a taser a deadly force weapon utilized by a resistive subject? I guess that must be I don't know, maybe that's the title of the article. So all these less than lethal weapons, folks, well, I shouldn't say all of them, but the more common ones, things like pepper spray, things like a taser, these should properly be understood as being less than lethal, non-deadly force, not likely to cause or contribute to death or serious bodily injury when they are used as intended defensively. So if an innocent person is attacked by a criminal and they pepper spray the criminal, their intent is to neutralize the threat of unlawful force against them. They're not going to follow up the pepper spraying by stomping that criminal's head into the sidewalk, right? They're just trying to neutralize the threat. With police, they're using pepper spray or a taser, whatever, to compel compliance with lawful orders, to compel compliance with a lawful arrest, for example. They're not going to taser the subject or pepper spray the subject and then beat the subject with nightsticks after they're cuffed. Or if they did, that would clearly be unlawful, right? But the expectation is that's not what's going to happen when the OC or taser is being used in a defensive manner. If OC or a taser is being used in an offensive manner, however, it's quite different. If it's being used in an unlawful offensive manner. So it's quite common in bank robbery cases for bank robbers to go into a bank, hose everybody down with pepper spray to facilitate their ability to rob the bank. When they're caught, as they almost always are, bank robbers tend not to be the smartest group of people you've ever met. When they're caught, they're routinely prosecuted by the federal authorities because bank robberies are typically federally prosecuted these days. They're prosecuted for their use of the OC spray inside the bank on the tellers as having committed aggravated assault or aggravated battery on the tellers. Aggravated meaning felony level, meaning readily able to cause death or serious bodily injury. Because the burning and the discomfort and the impaired breathing is characterized as serious bodily injury, even if it is transient. And those prosecutions are effective. They get convicted. So what would have been a non-deadly tool, OC spray, when used defensively, becomes a deadly force tool, meaning readily capable of causing death or serious bodily injury, a deadly force tool when used offensively. Same with a suspect who grabs control of an officer's taser. When the officer uses that taser to compel compliance with a lawful arrest, he's going to neutralize the subject and cuff up the subject and do the lawful arrest. He's not going to continue committing unlawful acts upon that subject. When a subject uses that same taser offensively, unlawfully against a police officer, it's reasonable to infer that the unlawful act of aggression will continue for as long as that aggressor wants it to continue, if he's able to disable the officer. And of course, the officer also has a gun on this person that he can no longer defend, that's readily accessible to the unlawful aggressor. So a police officer fighting with a non-compliant suspect who loses control of his taser to that suspect, and the taser is theoretically capable of immediately disabling that officer, is not facing a non-deadly force threat. He's facing a deadly force threat. So whether or not OC spray or a taser qualifies as a use of deadly force, force readily capable of causing death or serious bodily injury, or merely non-deadly force, depends on the manner of its use. Is it being used for a lawful purpose with no reasonable inference of ongoing harm to the person against whom it's being used, or is it being used to facilitate ongoing harm, felony degree harm to that person? It's much the same like when a police officer handcuffs a suspect. That handcuffing is not a crime. It's being done to facilitate a lawful arrest. When a kidnapper handcuffs the victim, that's not the same thing, is it? That becomes an unlawful restraint, and kidnapping is a deadly force act because of the likelihood that the victim will suffer death or serious bodily injury in the course of the kidnapping. Okay, let's see. Next question. Unnamed. Oh, that's an administrative question for the membership for support. Let's see. Another question from Jonathan actually touches on precisely the same issue. Any initial thoughts on the Patrick Leoya shooting in Grand Rapids? This is a case where an officer was making a lawful arrest of a suspect. The suspect seized control of the officer's taser, would not relinquish control, and the officer ended up shooting the suspect after the suspect refused to relinquish control of the taser. My initial impressions of what I've seen in the video in that case is that that was a justified use of deadly force by the officer under those circumstances. The prosecution has decided to prosecute that officer with murder. Of course, the officer's been fired, but firing doesn't mean anybody did anything illegal. I mean, you could be fired really for almost any purpose, and even if the purpose is uh, for any reason, and even if the reason is unjust, that's something that would be settled later in civil court or arbitration. Meanwhile, you're still fired. So the mere fact that an officer has been fired by his department sometimes that's a recognition that the officer did something obviously criminal. Other times it's the police department wanting to make a political problem go away in the most expedient way possible. And sometimes that's simply by firing the officer, whether that's a justified termination or not. So I'm open to argument on that case. There may be additional evidence that's developed. Perhaps the officer did overstep reasonable bounds of use of defensive force. I remain unconvinced. And of course, the officer is presumed under our criminal justice system to be innocent until proven guilty. And the state has to disprove his claim of self-defense beyond any reasonable doubt. So it doesn't matter, or it's not sufficient, I should say, if the prosecution can show the jury by 60% or 70% of the evidence that this was an unlawful use of force by the officer. They have to show beyond any reasonable doubt that it was an unlawful use, or the shooting is justified. All right, let's see. Next. He's asking about a specific case we wrapped up some time ago, but he's asking about a particular legal defense that's called the legal defense of duress. Duress is when you're being compelled to engage in some normally criminal conduct by some external pressure. And it could be someone kidnaps your child and puts a gun to your child's head and says, rob that bank across the street or I'll shoot your child. And you go and rob the bank. You're not doing that of your own free will. You're doing that under duress. And duress is a legal defense. Now, self-defense is what we would call a justification defense, meaning the outcome is a social good. So a woman is attacked by a rapist. She shoots and kills her rapist. The rapist being shot and killed by the intended victim is a social good relative to the woman having been raped, right? Society has a definite sentiment about which of those outcomes they prefer. Duress is not really a justification defense. It's an excuse defense, as Kevin mentioned in his asking of the question. And an excuse defense is different from a kind of public policy perspective than a justification defense. In a justification defense, the outcome is desirable. It's a social good. In an excuse defense, the outcome is not necessarily socially desirable. Robbing a bank is bad, right? There's never a lawful robbery of a bank. But we excuse the unlawful conduct because of some other factor. One of those can be duress. There was some compulsion put on the actor so that the normally criminal conduct was not really of his own free will. Much the same is true of the insanity defense. So a crazy person walking down the street shoots and kills a pediatric oncologist. Well, it's not good for society that a pediatric oncologist was killed, certainly, but we may excuse the killing, not criminalize the killing. No criminal liability on the basis of insanity. So the legal defense of insanity would be another excuse defense. So yeah, I mean, can the legal defense of duress be successfully raised? Sure, it can, of course. It's a very traditional excuse-based legal defense. Is it often raised successfully? No. Again, much like self-defense, most claims of self-defense are BS. These are bad actors raising the claim of self-defense because that's what their lawyers do when they're charged with the use of force offense. One of the defenses you raise is self-defense. Very often, if people who are actually unlawful dealers of illicit drugs, for example, they're caught in possession of the drugs, most possession cases are pretty open and shut. I mean, you had the illicit drugs or other contraband on your person. It was in your possession. Possession is all that's required for criminal liability. But one of the defenses you might raise is duress. Hey, I didn't have those drugs on me, a young woman might say, because I wanted to. My drug dealer boyfriend compelled me, placed me under duress, threatened me with harm, or threatened to harm my child unless I carried these illicit drugs on my person. It's not very often successful because often there's insufficient evidence of the actual duress. The mere existence of a child, for example, that would be accessible to the drug dealer isn't by itself evidence that the drug dealer was threatening the child or using the child to create duress on the part of the woman caught with the drugs. But it is a defense. I mean, I would raise that defense under those circumstances. It's just one of the things you try. Let's see what else. Okay, let me turn to the super chats. I think I've covered all the, we're back now to looks like early April. So I think I've covered all the platinum member questions that are relevant to the current time period. Let me take a look now at the super chats. Again, if you'd like to submit a question in super chat, it needs to be $10, folks. That's the threshold. I'll refresh this and I'll come here. And what do we have? Looks like just two. So Seth Setch, sorry. $10 super chat. In regards to Indiana, are there any laws that would trip up someone using self-defense, like merely drawing the weapon in escalating the situation and thus losing innocence and or proportionality? Yeah, yes, all of that. So in any state, there's always facts that could be present or claimed to be present that would undermine self-defense. Remember, there's 5 elements, up to 5 elements of a claim of self-defense. And the goal of the prosecution is to disprove any one of those elements, any one of the 5 beyond a reasonable doubt. He doesn't have to defeat your claim of self-defense in its entirety. Those required elements of self-defense are cumulative. They're like links in a chain. If any link is broken, the chain is broken. So every required element is a target of attack for the prosecution. So when a prosecutor gets that investigative report about your use of force event, that's what he's looking for. Are there building blocks of evidence here from which I believe I can disprove any required elements, any single required element of self-defense beyond a reasonable doubt? If I can, then I can crush this person's claim of self-defense, which is bad because when you claim self-defense in the first place, you're necessarily conceding to the underlying physical conduct. So you're not saying, I didn't shoot that guy, it was somebody else, I have an alibi. You're saying, I shot that guy, but I did it in legal self-defense. Well, the prosecutor can destroy your claim of self-defense. All that's left of that sentence, I shot that guy in self-defense, is I shot that guy. Self-defense is gone. So if there's any facts from which a prosecutor can attempt to disprove any single element of self-defense beyond a reasonable doubt, yeah, absolutely. That can trip you up, quote unquote, on your argument of self-defense. Going to the gun too early is a very common way of this happening. So most of the cases I consult on as an attorney are cases involving law-abiding people, never been in trouble with the law a day in their lives, who find themselves charged with aggravated assault with a firearm. They're looking at 10 to 20 years in prison if they're convicted because they went to the gun under circumstances where the prosecution does not believe it was justified. Often they are attacked on the element of proportionality. So proportionality says if you're only being threatened with non-deadly force, you can only use non-deadly force in self-defense, like pepper spray. You can't go to the gun unless you're threatened with deadly force. But unfortunately, a lot of people are walking around with just a gun and no non-deadly means of self-defense. And when they get scared, even if they're only being scared with non-deadly force, they go to the gun because it's the only defensive tool they had. And now they're going to the gun under circumstances where going to the gun is arguably not lawful. So they acted disproportionately. They went to deadly defensive force when they are only facing a merely non-deadly force threat. Very common. And you lose the element of proportionality and you lose self-defense. The whole house of cards comes down. A similar argument can be made in the context of the element of innocence. So arguably, if someone threatens you with mere non-deadly force, they shove you, for example. That's not allowed. That's a simple battery, but it's a non-deadly force battery. You could lawfully respond with non-deadly defensive force to stop the next shove. But if you go to deadly force, you've arguably escalated what was a non-deadly force fight that the other guy started. He's the initial aggressor in the non-deadly force fight. You've arguably escalated that to a deadly force fight in which you are the deadly force aggressor in what the law would now view as a new fight. The other guy's on the hook for the non-deadly force fight. He's on the hook for that shove. He's on the hook for that simple battery. But if you escalate a non-deadly force fight to a deadly force fight by going to your gun, you're arguably the deadly force, unlawful aggressor in a second fight, a new fight. And as the unlawful aggressor with deadly force, you've lost the element of innocence and you've lost self-defense. So that's how that would work. I mean, there's a lot of ways to lose self-defense, all targeting those key 5 elements. So important to know what those are. Warren Lee asks, regarding an RV in transit to a new location, does it qualify when it's in motion from camping 1 to camping 2? Certainly, I would make that argument with a straight face. If you're living in the RV, it's your temporary dwelling while it's parked and while you're in it, while it's moving. Now, if you, could it become more complicated if you say you park in a Walmart parking lot, you get out of the RV, you're going into the Walmart to buy food or something, and you're involved in a use of force event there? Might a prosecutor argue that at least while you're outside of the RV, you're not living in it in the moment it's not a dwelling? Maybe. I mean, prosecutors can raise any argument they want. Really, it wouldn't be a very compelling argument to me. While you're using it to camp in, from the moment you leave home until the moment you return home, or otherwise put the RV back into storage or whatever you do with RVs when you're not actually living in them, that entire process, I would credibly argue that it's your temporary castle, your temporary dwelling from beginning to end. Let's see if there's any new ones here. Again, if you want to ask a question and have the expert answer, that expert would be me, Attorney Andrew Branca of Law Self-Defense. Thank you very much. I would be happy to do that, but it has to be a super chat in the amount of at least $5. All right. Eminem. Thank you for your $10 super chat. Asks, based Branca, any opinion as how body armor falls under the Second Amendment? Does not arms equals armament? Defensive and offensive. Hoping Mrs. Branca is doing well with her recovery. Yes, Mrs. Branca was diagnosed with cancer some months ago, underwent surgery for that, and it appears to have been completely effective. She's doing wonderfully. She's back at 150%. So that is all great. She's doing fantastic. And so let me get to this question. What about body armor? I don't know whether or not body armor would qualify under the Second Amendment. I frankly would think not. Now, just because something doesn't qualify as the Second Amendment doesn't mean you ought not have the privilege to own it. But I'm not sure the Second Amendment specifically would cover something like body armor because it covers arms. And arms, body armor, to my mind, is not something you would use against another person, which is what an arm is. Same if we were talking shields. Would a shield be an arm? Maybe. I mean, if is the combination of shield and sword, but then there's a sword. So would a shield alone be an arm? If all you had was a shield? I wouldn't think so. So I wouldn't think body armor would be. Now, I think there are some states that prohibit civilian ownership of body armor, and I think they're about as stupid as as laws that restrict gun ownership by law-abiding, mentally sound American citizens. Bad guys don't obey laws. They don't obey gun laws. They're not going to obey laws prohibiting civilian possession of body armor. So I think such laws would be ridiculous, but completely ineffective and pointless, as if we don't have enough of those kinds of laws as it is. But whether it would actually be covered under the Second Amendment, I think that's a real stretch of the Second Amendment. Let's see. I think that is about one more refresh on the super chats. Oh, by the way, folks, if you're watching on YouTube and if you have not yet hit the subscribe button, I would greatly appreciate it if you could do that. We did just cross 40,000 subscribers. So many, many thanks to all of you for that. Can't believe it. 40,000 subscribers and a few hundred at this point, but the more the merrier. The more subscribers we have, the more we can fool the YouTube algorithm into sharing our content more broadly, which is our mission here, of course, is to grow the law self-defense community so we can help people be hard to convict by keeping their use of defensive force within the legal boundaries. Also, if you're on Twitter and you don't yet follow me on Twitter, that would be appreciated. We're just a few hundred people, I think 100 or so, followers from 60,000. So our Twitter handle is at law self-defense. No, I'll put it here under my face. Spelled it correctly. At law self-defense. No of. For some reason, it wouldn't allow me to have the of. At law self-defense. So if you're on Twitter, you don't follow me yet there, that would be appreciated. We're really trying to get, in fact, let me see what the exact count is right now. We were pretty close this morning to 60,000, and we are currently at 59,637. So we're less than 400 away from 60,000. If any of you are on Twitter and would follow us at Law Self-Defense on Twitter, that would be great. All right, folks, I don't have any more super chats, and I've gone through all the platinum member questions I have to go through. I would encourage you all again, if you haven't yet done it, to pick up your free copy of our book, The Law of Self-Defense Principles. You can get that at lawselfdefense.com/free book. You can buy the book on Amazon if you want. It's got 1,000+ reviews, 5-star rating, but they'll charge you for the book and shipping. We only ask you to cover the cost of getting the book to you, the shipping and handling. If you'll do that, we'll send you the book for free. It's frankly, the single best thing you can do for yourself in helping you be not just hard to kill, which is why you carry a gun for personal protection, right? That's why I carry a gun for personal protection, but also to ensure for your own benefit, for your family's benefit, that not only are you hard to kill, but you're also hard to convict. Not through learning legal tricks, but by knowing where the legal boundaries of self-defense actually are and making sure you stay well within them. Because nobody in court cares what your good faith belief in self-defense law was, if it's inconsistent with the actual law of self-defense. In court, they only care about whether your conduct actually falls within the actual law of self-defense. So you need to make sure you're doing that. And our book, Law of Self-Defense Principles, is a big step towards you doing that. And we basically give the book away, folks. So get that at lawselfdefense.com/free book. All right, folks, that's all I have for the moment. Again, until we meet once more, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe. And once again, I forgot my little exit video. Here we go.